What if I told you that after Jeffrey Epstein walked out of the Palm Beach County stockade in July 2009, a registered sex offender, a convicted felon, he didn't disappear. Pause. He didn't hide. He didn't downsize. He returned to his $71 million Manhattan townhouse at 9 East 71st Street. He kept his private island. He kept his ranch in New Mexico. He kept his jet. Pause. And over the next 6 years, while the world moved on, while investigators closed their files, while prosecutors turned to other cases, Jeffrey Epstein rebuilt. He socialized, he hosted, he traveled, and according to court filings that wouldn't be unsealed for years, Village, the network never stopped. Pause. Stay till the end. Because what happened during these so-called quiet years is the reason dozens of powerful people are still answering questions today. I'm Mark Epstein, and this is the Epstein Files. Pause. On July 22nd, 2009, Jeffrey Edward Epstein completed his 18-month sentence at the Palm Beach County stockade. Though, as we covered in a previous episode, much of that time was spent outside the facility on a controversial work release program. Source: Palm Beach County Sheriff's Office records, Miami Herald, Perversion of Justice, Part 3. Upon his release, Epstein was required to register as a sex offender in the state of Florida. And because he maintained residences in multiple states, in New York as well, he registered as a Level 3 sex offender, the highest classification, with the New York State Division of Criminal Justice Services. Source: New York State Sex Offender Registry, Palm Beach County Court records. His primary residence remained the Manhattan townhouse at 9 East 71st Street, one of the largest private residences in New York City, valued by property records at approximately $77 million. Source: New York City Department of Finance property records. He also retained ownership of his private island, Little St. James, in the United States Virgin Islands, purchased in 1998. He maintained his property at 358 El Brillo Way in Palm Beach, Florida, and his Zorro Ranch near Stanley, New Mexico, a nearly 8,000-acre compound in Santa Fe County. Source: USVI property records, Palm Beach County property records, Santa Fe County property records, referenced in Case 19 CR 490 SDNY. For most convicted sex offenders, life after prison means restrictions, limitations, and social exile. For Jeffrey Epstein, it meant something entirely different. Pause. But here's where it gets disturbing. Pause. Between 2009 and 2015, Jeffrey Epstein was not a man in retreat. Court documents filed in subsequent cases, particularly in Virginia, Giuffre vs. Ghislaine Maxwell, case number 15 CV 07433 in the Southern District of New York, and records later presented during the federal prosecution in case 19 CR 490, paint a picture of a man who remained socially embedded among the wealthy and influential. Source: Pacer, case 15 CV 07433. Case 19 CR 490. Consider the financial picture first. According to financial records that later became part of civil litigation, including the lawsuits against JP Morgan Chase and Deutsche Bank, Epstein maintained his banking relationships well into the post-conviction period. JP Morgan Chase continued to maintain Epstein as a client until 2013. Source: Jane Doe, Hwan v. JP Morgan Chase. Case number 22, CV 119, SDNY, JP Morgan Settlement, June 2023, $290 million. According to the complaint in that case, Epstein maintained multiple accounts with JP Morgan, and the bank processed transactions for him throughout the period from 2009 through 2013, despite his sex offender status. The complaint alleged that senior executives at the bank were aware of Epstein's conviction and the nature of the underlying conduct. Source: Case 22 CV 119 SDNY complaint. Deutsche Bank entered a relationship with Epstein in 2013, the same year JP Morgan ended its relationship, and maintained him as a client until 2018. In July 2020, the New York State Department of Financial Services announced that Deutsche Bank would pay a $150 million penalty for, among other compliance failures, its relationship with Epstein. The DFS consent order stated that Deutsche Bank processed hundreds of transactions for Epstein that should have raised red flags, including payments to individuals who had been publicly identified as Epstein's co-conspirators and payments to Russian models. Source: NYDFS consent order, July 7, 2020. Deutsche Bank settlement, civil lawsuit, $75 million to victims, announced May 2023. So between 2009 and 2015, Jeffrey Epstein had full access to the international banking system, maintained accounts at two of the world's largest financial institutions, and moved money freely. Pause. The flight logs tell another part of the story. Subpoenaed records of Epstein's aircraft, including the Boeing 727, known publicly as the Lolita Express, and smaller aircraft, documented extensive travel during the post-conviction years, according to flight manifests obtained through civil litigation and later referenced in federal proceedings. Epstein continued traveling between his residences, New York, Palm Beach, the Virgin Islands, New Mexico, and internationally, including trips to Paris and other locations. Source: flight logs subpoenaed in civil litigation, referenced in Case 15 CV 07433 and Case 19 CR 490. Now, if you're still here, it means you can handle the truth. So let me show you what they didn't want you to see. Pause. While Epstein was living his post-conviction life largely undisturbed, his victims were fighting. And it is their actions during these years, not law enforcement, not prosecutors, not regulators, that ultimately cracked the case back open. Pause. On September 21st, 2009, just 2 months after Epstein's release from the Palm Beach stockade, attorneys representing two victims, identified as Jane Doe No. 1 and Jane Doe No. 2, continued their legal battle in Case 0880736 CIV in the Southern District of Florida, arguing that the government had violated the Crime Victims' Rights Act by concealing the non-prosecution agreement. Source: phir, Case 0880736 CIV. That case, as we discussed in episode 25, would not be resolved until Judge Kenneth A. Mara's ruling on February 24, 2019, a full decade of litigation by victims against the United States government. Source: phir, Case 0880736 CIV. Order, February 21, 2019. Meanwhile, Virginia Roberts Giuffre was building her own case. In 2015, a critical legal filing reshaped public understanding of the Epstein network. On January 2, 2015, Giuffre, through her attorneys Paul Cassell and Bradley Edwards, filed a motion in the CVRA case in Florida seeking to join the proceedings. That filing contained detailed allegations about Ghislaine Maxwell's role in the trafficking network and named specific individuals Giuffre said she had been directed to have sexual encounters with. Source: phir, Case 0880736 CIV, Jane Doe No. 3. Motion to join, filed approximately January 2015. Contemporary reporting. Then on September 21, 2015, Virginia Giuffre filed her defamation lawsuit against Ghislaine Maxwell, case number 15 CV 07433, in the Southern District of New York. The suit was filed after Maxwell publicly called Giuffre's claims obvious lies. Source: phir, Case 15 CV 07433 complaint. This single lawsuit would generate thousands of pages of depositions, discovery documents, and sealed materials that, when finally unsealed beginning in 2019 and continuing through 2024, would expose the inner mechanics of Epstein's operation in unprecedented detail. Source: phir, Case 15, CV07433, Document Cloud, Unsealed Documents. During the discovery phase of the Maxwell defamation suit, Ghislaine Maxwell was deposed on April 22, 2016 and July 22, 2016. In those depositions, which were sealed at the time but portions were later unsealed by court order, Maxwell was questioned extensively about her relationship with Epstein, about the recruitment and transportation of young women, about specific properties, and about her interactions with named individuals. Maxwell invoked her Fifth Amendment right against self-incrimination in response to certain questions, while denying allegations in response to others. Source: phir, Case 15 CV07433. Maxwell depositions, April 22, 2016 and July 22, 2016, unsealed by court order. Virginia Giuffre herself was deposed during the same litigation. Her testimony, portions of which were later unsealed, provided detailed accounts of how the network allegedly operated, the recruitment methods, the locations used, the role of specific individuals in scheduling and facilitating encounters. Source: phir, Case 15 CV07433, Giuffre deposition, unsealed documents. This is where the official story falls apart. Pause. Because during these so-called quiet years, 2009 through 2015, while Epstein was treated by the system as a resolved case, a settled matter, a man who had served his time, the documentary record shows something entirely different. The SDNY indictment filed on July 2, 2019, Case 19 CR 490, charged Epstein with sex trafficking of minors and conspiracy to engage in sex trafficking of minors, and the conduct charged included acts committed in New York between at least 2002 and 2005. Source: phir, Case 19 CR 490, indictment. But the investigation that led to that indictment relied heavily on evidence that emerged from civil litigation, especially Giuffre versus Maxwell, and from the Miami Herald's Perversion of Justice series, published beginning November 28, 2018, by investigative reporter Julie K. Brown. Source: Miami Herald, Perversion of Justice, contemporaneous reporting on SDNY investigation origins. The question is this: during the years between 2009 and 2015, while victims were fighting in court and assembling evidence at their own expense, what were federal authorities doing? Pause. According to the DOJ's Office of Professional Responsibility report, released in November 2020, the non-prosecution agreement had effectively closed the federal investigation in the Southern District of Florida. The NPA's immunity provisions, extending to any potential co-conspirators of Epstein, meant that the USAO SDFL did not pursue further cases against individuals in Epstein's network. The source: DOJ OPR report, November 2020. There is no public record of any active federal criminal investigation of Jeffrey Epstein or his associates between the execution of the NPA in 2008 and the SDNY's investigation that began, according to public reporting, in late 2018 following the Miami Herald series. Pause. That is a decade, a full decade, during which a convicted sex offender maintained his properties, his aircraft, his banking relationships, his network, while the victims fought alone. Pause. As we explored in episode 25, the immunity clause in the NPA shielded not just Epstein, but unnamed co-conspirators. As we will explore in upcoming episodes, the period after 2015, when Giuffre's lawsuit began producing discovery, is when the documentary evidence started to accumulate that would eventually force federal action. But this episode, episode 29, is about the gap. The years when the system was silent, when the money still moved, when the properties were still staffed, when the jet still flew. Pause. And it is about the victims, Virginia Giuffre, Courtney Wild and others, who refused to let the case die. Court records from case Aero A880736 CIV show that victim attorneys Bradley Edwards and Paul Cassell filed motion after motion, year after year, keeping the CVRA challenge alive when every institutional incentive pointed toward letting it go. Source: phir. Case 08-80736 CIV, docket entries 2009-2019. These women and their attorneys did what the federal government would not. They kept the paper trail alive. They kept the legal pressure on, and ultimately, it was the evidence generated through their civil litigation, not through any proactive federal investigation, that built the foundation for the SDNY charges in 2019 and the Maxwell prosecution in 2020. The quiet years were not quiet. They were years of deliberate institutional silence and relentless, exhausting, underfunded resistance by the people who had been harmed the most. The powerful bury the truth, but paper has a longer memory than power. If this episode opened your eyes, hit subscribe and the bell icon, because every file matters. Comment below, why do you think it took a decade for federal authorities to act? I read every single one. Share this before it disappears from your feed. Next file, Episode 30, The Miami Herald Investigation. How one journalist, Julie K. Brown, did what the FBI, the DOJ, and every federal prosecutor's office in the country did not. When you hear how she got the story, you'll understand why they tried to stop her. I'm Mark Epstein, and I'll see you in the next file.